hopefully everybody made it over here safely. I will get some bingo cards for this one up because I do have some bingo cards for this one. So I will bring those bingo cards up very shortly. For those who were doing their bingo for the other case that we just left, just hold on to them. All right. I do have the link, the last link, so I'll be able to post it back up there and everybody should be able to get back to their bingo card. Yes, that's how it works. I don't know. We shall see. I know. What can I say? I don't know. I don't make participate in them in some type of way. Wait a minute. Okay, I should be good now. I was talking back to myself, and I don't want to talk back to myself. Okay. Oh, Dusty. Old Dusty is what I like to call him. Old Dusty. Let's see what we got going on with Mr. Dusty. Oh, Dusty. Dusty. Dusty gonna have to testify. Oh, Dusty. I know that interview that he had that they was showing the other day was brutal. I was like, oh my goodness, what is he? This man was in there talking for hours and hours and hours. So they on lunch. So I guess we right on time. Get us some TiVo time. Oh, Dusty. Oh, Dusty. Am I on the phone? Nah. I'm not on the phone. Why you ask me that? I'm talking to you about Dusty. Okay. Oh, I'm gonna get the bingo card up for Dusty. Oh, Dusty. I don't know. For some reason, I want to be like Nutbush City. I want to sing like Tina Turner now. Oh, you was talking to Lynn? Nutbush City now. Is that Dusty? Hey, 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 hey. Hey, 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 hey. Nutbush City now. Okay. Okay, 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 okay. Okay, so check it. Let's play bingo. Bingo. B-I-N-G-O. 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 And bingo was his name. Oh, there was a farmer had a dog at bingo. Oh, y'all remember that song? Oh, B-I-N-G-O. B-I-N-G-O. Okay. I need to quit. Everybody get their bingo cards together. B-I-N-G-O. 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 And bingo was his name. So wait a minute. I am having all types of technical difficulties up here. You know, I can't stand these iPhones at points and periods of times because sometimes they just be doing too much. Now I want to know who this person is right here. Oh, free. Oh, they got 2 free spots. Oh, shoot. Oh boy. Somebody that found 2 free spots and they ding those ones real quick. Ah, oh well. Okay. So check. So I'm up back here in the back and I had to do a warranty claim for my phone, right? I'm gonna tell y'all how messed up things can be. Now, I had to do a warranty claim for my phone. No, I don't want nobody winning bingo. Nah, I don't care. Y'all, I'm putting everybody's name in the thing. As soon as the trial over, you get, you know, whatever. Um, what was I gonna say? So, so I'm trying to set up my phone, right? And for some reason, please explain to me how the password that I put in my phone all the time on my Apple phone. Can y'all please explain to me why it's not working right now? Like it's telling me that I got the wrong password when I'm trying to tell it I do got the right password. Like these things just think they so smart. So I've been locked out for 1 minute. I've been locked out for 5 minutes. I have been locked out for 15 minutes, and I am about to be pissed if it locked me out my phone again. Like I can't use my phone. And this is the passcode that I know. Oh my gosh. Like what a dang on mess. Mm. Yeah, and I can't even call nobody. Like I can't even phone a friend. No, couldn't nobody change my password because they don't have access to it. I mean, like this is crazy. It say your password is required, and I know my password. I mean, I can't be having that much of a brain fart, could I? I mean, I guess I could have a big brain fart. I don't know. Yes, an iPhone. Now it's unavailable for 1 hour. I can't deal with them. I don't want nothing to lock me out my phone that long. I mean, a whole hour. So I don't know. Yeah, saying you can try your password again in an hour, or you can erase and reset this iPhone now. And so my other phone is stuck. Well, we gotta wait an hour because I can't do nothing. This is such bull crap. Okay, I can't even do nothing on the phone. So if you text me, trying to reach me, that's why I'm not doing anything because I can't do anything. And I know my past
Good morning.
don't
Thank you for being
understand
seated.
how instead of
Okay, members of the jury, thank you again for your service and your punctuality. As I ask you every morning, because there is a media presence with respect to this jury, please, I would ask you now to raise your hand if you have had any exposure, even if it was inadvertent, relative to any of the media coverage with respect to this matter. Let the record reflect that none of the jurors have raised their hands. Thank you again for your adherence to my instructions. Thank you. And Attorney Kettle's ready to proceed?
Yes, Your Honor.
Detective Sergeant, you're still under oath, sir.
Yes, sir.
Thank you.
Detective Sergeant, I'm going to back us up a little bit and just go through in some bite-sized chunks, okay?
Okay.
So we were talking about the incident itself, what Dustin told you about the incident. He said it happened super fast.
Yes.
He said, I mean, there was, again, it was like training to where it was, he said, I mean, there was, again, it was like training.
Yes.
He said, to where it was just grabbed it, cocked, grabbed Elwyn, and then right when I shot, it was just immediately I grabbed Elwyn and like ran out of the house.
To the car.
Yes, I'm doing it in bite-sized chunks here. Yes.
Okay. Yes.
And just immediately ran out of the house and put her in the car.
Yes.
He said after he put her in the car, he sat for a minute talking to Elwyn.
Yes.
He was making sure that nothing had happened to her.
Correct.
He was checking to make sure she didn't have injuries.
Yes.
She didn't.
Correct.
He loaded the car up.
Yes.
He got the kids in the car.
Yes.
He was thinking, at some point, I'm going to turn myself in.
Yes.
But first, he was going to spend some time with his kids.
Mm-hmm. Correct.
He said he drove to Concord.
Yes.
Once he got to Concord, he sat with Elwyn and Valen again.
Yes.
And at that point, they were both good and they were happy.
Yes.
He called his mom and told her what had happened.
Yes.
And he told her to call the cops.
Probably should call the cops is my recollection, but something to that effect, yes.
He told his mom he was going to turn himself in.
I believe so, yes.
He told her he wanted some time with the kids beforehand.
Yes.
He told you that after he talked to his mom, he turned his phone off.
Correct. Went dark, I believe is what he said.
He said went dark, and he said, I turned my phone off.
Yes.
He said he drove to somewhere in New York State.
He believed it was New York State. Yes.
He and the kids got a few hours sleep.
Correct.
He woke up and initially thought, well, I'll just surrender at a random police department.
Yes.
But then he decided he should probably do it in New Hampshire.
Correct.
And by do it, he was referring to surrendering or turning himself in.
Yes.
So then he started heading back.
Yes.
He decided to go to Concord and then just surrender there.
That was his plan, yes.
But he wanted to just sit down with the girls and just have breakfast somewhere.
Yes.
couple more questions on what Dustin said in relation to his training. Dustin said everything was so fast. It really was like training. It was instant.
Referring to his marksmanship training, yes.
He said it was like muscle memory.
He did say that.
He said it was his training coming out.
He did say that, yes.
One moment. No further questions.
Sergeant McLaughlin, just two questions. How many police stations or police barracks are in Keene?
So there's a state police barracks in Keene, so that's one. The Keene Police Department is two, and the Cheshire County Sheriff's Department is in Keene as well, so that's three.
And to the location where he was originally stopped by, or initially stopped by police, he passed right by your barracks, is that correct?
He even commented that he saw the sign for the state police barracks.
And he avoided that.
Yes,
Now, how many police stations between Keene and Concord?
a lot. You don't expect me to know how many, do you?
No, that
Okay,
many, right?
a lot.
You can't even judge.
And even from the Vermont border into New Hampshire, there's at least Chesterfield Police Department.
Okay. Did the defendant talk to you about whether he had a connection to Concord, New Hampshire?
No,
Now, everything in the defendant's statement, all of the words that he provided to you, that's what he told you, correct?
that's correct.
Anybody else tell you those words?
No.
No other questions?
Recross?
No, Your Honor.
Okay, thank you. Can Detective Sergeant McLaughlin be excused?
Yes, Your Honor.
Okay, thank you.
Thank you, Ron.
Turner, may I approach the monitor?
Sure.
Your Honor, at this time, the state has no further witnesses and we would rest.
Okay. All right, thank you. Okay, members of the jury, at this time, I know that we just started for the day, but we are going to be taking a break at this point. So I'm going to request again that you retire to the deliberation room. Please do not discuss any aspect of the case. Do not discuss it with any other member of the jury. If anybody does that, please report that to a court security officer. And thank you, and we'll resume as soon as we can. Okay?
All rise. state has disproved the affirmative defense of others, and therefore the court must dismiss all 4 charges. Specifically, Dustin was justified when he shot Caitlin, and all charges must be dismissed. The state offered evidence that Caitlin died from a gunshot wound to the head and that the gun that was shot was Dustin's and was found in Dustin's car upon arrest. However, the state introduced the defendant's own statements through Detective McLaughlin, which offer enough evidence of justification. And so the burden shifts to the state to prove it was not justified. Dustin told the state in his interview how and why he was justified. Specifically, he described Caitlin refusing to leave his home. He said Caitlin was getting more and more aggressive. Caitlin told him she was going to take the kids away from him. Caitlin told him she was going to call the cops and have him arrested. Caitlin grabbed Elwin and was not letting go. She was again threatening to take the kids. Caitlin was saying she was going to take Valen and Elwin back to Minnesota. Dustin tried to grab Elwin and be like, hey, let go of Elwin. And Caitlin just wouldn't let go. Caitlin had Elwin in a bear hug, a 2-handed bear hug. Dustin tried to grab Elwin a couple of times. He couldn't pull that much because he did not want to hurt Elwin. Elwin was yelling. Elwin was crying. Caitlin was holding Elwin forcefully enough to cause her to cry. Dustin said he grabbed the gun, chambered it, and while grabbing Elwin, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Elwin. Dustin said everything was so fast, it really was like finger snapping, training. It was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Elwin, ran out of the house, put her in the car. He sat for a minute talking to Elwin. He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she didn't. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C is committing or about to commit a kidnapping. Or D is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlin used force against Elwin when she restrained Elwin in her arms while committing a burglary. She entered or remained unlawfully in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping or 633-4 interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlin was threatening to do so. She was attempting to do so. She was refusing to leave the home or release Elwin. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Elwin to Minnesota or to New Hampshire. Harassment with the purpose to annoy or alarm another, communicates any matter containing or any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person's actually placed in such fear. And the course of conduct would be restraining and yanking back element. Theft by extortion. A person is guilty of theft as he obtains or she obtains or exercises control of the property of another by extortion and with a purpose to deprive him thereof. As used in section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened or to any other person or to property at any time, or B, subject the person threatened or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining element. Theft by deception. A person commits theft if he obtains or exercises control over a property of another by deception with a purpose to deprive him thereof. Deception occurs when a person purposely creates or reinforces an impression which is false, in which that person does not believe to be true. Attempting to obtain Dustin's money, deception would be telling Berlin PD that he took Ellen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him. Evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlin was using unlawful force against Elowen when she was restraining her in her arms, squeezing her while attempting to commit interference with custody in Dustin's home. So she was in his home, she was attempting to commit a felony level offense using unlawful force. If the court disagrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect. Reckless conduct alleges that Mr. Duran recklessly engaged in conduct which placed another Elowen in danger of serious bodily injury by shooting Caitlin while holding Elowen. 2 reasons the court must dismiss for insufficient evidence. 1, the facts don't show beyond a reasonable doubt that Dustin was holding Elowen while shooting Caitlin. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Elowen. He grabbed the gun, chambered it, grabbed Elowen, pulled her back out of the way, and shot. The state alleges that this action was reckless, even though we have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting. He knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Elowen, that he pointed the gun at Elowen. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Elowen out of the way. He made sure that she was not at risk. He aimed the firearm away from her. We heard that the gun he used has many safety features and cannot accidentally discharge. In terms of the risk to Elowen, this is no different than if Dustin and a child were at a firing range and Dustin fired, not towards the child, but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired is not without more, without evidence that the gun was aimed at or near her, rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor, the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Ray NK, 169 New Hampshire 546 defines what endangering the welfare of a child means. A person is guilty of endangering the welfare of a child when he knowingly endangers the welfare of a child under 18 years of age by purposely violating a duty of care, protection, or support he owes to such child. So the state's required to prove 2 things: that Dustin knowingly endangered the welfare of Elowen two, that he did so purposely by violating a duty of care owed to her. So again, the evidence here is that Dustin grabbed Ellen from Caitlin and moved her out of the way while simultaneously firing one bullet in Caitlin's head. He said, right when I shot, it was just immediately I grabbed Ellen. He did not violate a duty of care. He acted out his duty of care to save her from harm, to remove her from the situation. There is no evidence Ellen was endangered. Evidence is sufficient to prove endangerment if it establishes, and again, this is from NK, In re NK, if it establishes that the offender engaged in behavior creating an actual and significant risk of injury to a child's welfare. The state didn't offer evidence of welfare but beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Ellen appeared well kept and well nourished. That's what Dr. Robertson said. There was no evidence of the volume produced from the gunshot. We heard evidence of the amount of pressure it takes to pull a trigger, but no one testified how loud the gun was. And the state did not present evidence of how loud a Beretta 9mm pistol is when it's fired. And that's no different, Your Honor, I would argue, that when you take a child to a musical festival with loud music without ear protection. And also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, I can see where this is going of like, could it be that I'm endangering Ellen by what I did? And I would very much say no. And then Sergeant McLaughlin responded, yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you weren't endangering Ellen. And Dustin responds, yes, I was not endangering Ellen. And to follow up, Your Honor, again, they have to prove the mental states of both knowingly endangering the welfare of a child and purposely violating a duty of care. Thank you.
Okay, Attorney Spicer.
Thank you, Your Honor. They asked that the court deny the motion. In the light most favorable to the state, there has been sufficient evidence provided for a rational trier of fact to find each element of the offenses charged. I'll note for the court, as this court is aware, it's the defendant's burden at this stage of the proceedings. I don't believe that they have met that burden. That's shown that any of the charges should be dismissed. I will start with the murder charges. The defense argued that there has been evidence presented of self-defense through the defendant's statement. I would not agree with that. At this point, I'll make arguments, assuming that to be true, but I would state for the record, I don't believe that that's true. The defendant's statement established that he told Sergeant McLaughlin that he killed Caitlin Nafziger very deliberately, that he did so because she refused to leave his apartment, that he did so after a day of arguments about things that they had been arguing by his own testimony for months and weeks. None of the statements that he claims that Caitlin made the day of the murder, that she was going to take the kids away from him, she was going to call the police, are things that were new to him. By his own testimony, she had said similar or identical things to him before in other contexts, and at no point did he shoot her in the head. His testimony, I think, was pretty clear, certainly in the light most favorable to the state, that he killed her because she wouldn't leave. He wanted to put her and the kids in the car so that he could drive them to her Aunt Brenda's house. He was in the process of doing that by his own statement. He put Valen in the car seat and got her ready to go. He was trying to take Ellen so that he could do the same thing, so that he could get Caitlin refused to let Edelman go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her. And so, just for purposes of the record, I don't think this is disputed. With regard to second-degree murder, both the knowing and the reckless varieties, there has been sufficient evidence presented as to each element of those offenses. That the defendant caused Ms. Knapsticker's death, and that he did so knowingly, and in the alternative, recklessly, with extreme indifference to the value of human life. The defendant has admitted that he pointed his gun at Caitlin's head and fired it. He has admitted that he knew the bullet went straight through. He has admitted, in essence, that he was aware that his conduct would cause Caitlin's death by pointing a gun at her head and pulling the trigger, particularly in light of his statements about his own expertise and his own experience with marksmanship and handling of weapons. So I don't think there's any argument there. I didn't hear anything from the defense about this. I'd ask that you find that the state has satisfied the elements of knowing and reckless second-degree murder. Again, keeping in mind that there has to be some evidence of self-defense before self-defense that shifts and the burden moves to the state. Understanding that the state does not admit that that has happened here based on the evidence before us. Even if that is the case, there is sufficient evidence at this stage in the light most favorable to the state where the rational trier of fact could find for the state. The case law on this is somewhat convoluted, so I don't want to misstate the standard, but I'm citing State versus Pennock here, 168 New Hampshire 294 at 307. It's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences therefrom in the light most favorable to the state, could have found beyond a reasonable doubt that the defendant did not act in self-defense. And that is an awkward formulation. But I would submit that there is certainly sufficient evidence before the jury for a rational trier of fact to find in the state's favor on that issue that the defendant did not act in self-defense beyond a reasonable doubt. I'll talk now. I'll refer now to the facts. The defendant must actually and reasonably believe that he is acting in self-defense for any of the various forms of self-defense to come into play. He must actually believe it, and that belief must be reasonable. The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlin. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, my plan all along was to turn myself in. He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, I acted in self-defense. At no point did he tell Sergeant McLaughlin, I did what I had to do. I didn't want to kill Caitlin, but I had to do it. Words to that effect. At no point did he say the word kidnapping. At no point did he say anything indicating he thought Caitlin was kidnapping the children. This kidnapping is a fabrication that the defense has presented here. The defendant himself did not believe it, and that's what the evidence shows, certainly in the light most favorable to the state. There is no evidence that the defendant believed it was necessary to use deadly force to defend himself or another. The defendant told Sergeant McLaughlin, when asked, that Caitlin did not threaten him, did not threaten Ellen physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense, or acted in self-defense, or acted because he thought Caitlin was going to steal his kids, or acted because he thought he was never going to see them again, or that he was necessary to prevent these things. The defendant called his mother and told his mother, in effect, I shot Caitlin, you should probably call the police. He didn't tell his mother, I had to do it. He didn't tell his mother she was going to kidnap the kids. He said, I shot Caitlin, or words to that effect, you should probably call the cops. the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner. I'll go through the various forms of kidnapping. I'll put this on the record, Your Honor. Under State versus Monroe, and I don't have the site handy. Here it is. 173 New Hampshire 469. The defendant not only must provide an actual notice of defense in support of the defenses they intend to pursue, but there also has to be specific presentation of or sufficient notice of the factual allegations supporting the defenses. With regard to burglary and all those other flavors of kidnapping flavors of self-defense beyond kidnapping, I don't believe that was done. Walking through each of the varieties of kidnapping in 627-4, starting first with 2A, I addressed that there is no evidence that the defendant acted because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B, the defense presented this court with a variety of crimes they claim that Caitlin could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duran's home. I can only imagine what the defense attorney would say if the state tried to charge someone in Caitlin's position with burglary, based on the statements and the facts and the circumstances in this case. I'm not going to address each of those crimes. I don't think it's necessary. I don't think the facts support them, and certainly not in the light most favorable to the state at this stage. There is sufficient evidence to show that the defendant did not actually believe Caitlin was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlin was going to have a purpose to commit theft by deception or false imprisonment or anything along those lines. So at this stage, in the light most favorable to the state, there is not sufficient evidence here, or there's not a lack of evidence that would allow this court, on the state of the evidence as it is, to dismiss the murder charge because of the defense arguments. 2D, 627-4-2D, defense counsel misstated the law. Defense counsel stated that under 627-4-2D, well, I'll state, the law says that a person justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor while inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlin was likely to use unlawful force in the commission of a felony against him. Defense counsel clearly claimed that he was going to use force against, that Caitlin was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that. And there's certainly not sufficient evidence that the state cannot defeat it, and there's no juror could find for the state on this issue. With regard to kidnapping, I'm going to ask the court to reference the arguments that we made in our pleading filed yesterday about the law. I can summarize them here. I don't want to get too far into the weeds, but to come back to the actual unreasonable belief, the court knows what the defendant said in that statement that was put into evidence. That is the evidence of what the defendant at this point actually believed happened inside that apartment. I'll note also that at this stage, credibility determinations with regard to witness testimony must weigh in favor of the state when they're equal. And the court can assess the credibility of the defendant's statements or different parts of the defendant's statements, taking into account that he is providing his account of what happened, his story of what he told the police about what happened. With regard to kidnapping, as we stated in our pleading, Ms. Nafziger legally could not kidnap her own child under 633(1)A. Could not do it. Based interplay of 633(1)A and 633(1) and 627(4)(2)C, as we say in our motion, interference with custody is not a basis for the use of deadly force. That is what the defense is arguing. The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlin could do. And to find that would be to add interference with custody to the list, to the narrow circumscribed list of circumstances where the law allows use of deadly force, and that should not be the case. And with regard to each of the different versions of kidnapping, at this stage, again, the defendant did not tell the police that he killed Caitlin because she was holding Elowen hostage. There was a reference to his training. The sergeant asked the defendant about if he had any sort of hostage training, and the defendant, it was somewhat difficult to see what he said or understand if he was giving an affirmative answer. He may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly, that's what I thought this was. This was a hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal, that the defendant actually and reasonably believed there was a hostage situation and that is why he killed Caitlin. And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlin was committing a kidnapping in ignorance of the law, which says that what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are, he is mistaken on what a kidnapping is in the state of New Hampshire. That is not an excuse. The defense argument is built upon the idea that ignorance of the law is an excuse, and this court should not agree with that. 633(1)(1)A is the ransom hostage situation. I'm not going to address that any further. 633(1)B says that there's a kidnapping if someone confines a person to avoid apprehension by law enforcement. There's no evidence that that's what was happening here, and defense has not claimed that. 1C, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlin was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay. And 633(1)(1)D would require that the victim confined, or Caitlin confined Elowen for the purpose of committing an offense against Elowen. That is not, there's no evidence that Caitlin was intending to hurt Elowen. And in fact, the defendant disproved that. He said, yeah, she was not threatening to harm Elowen. As Sergeant McLaughlin testified, the defendant told him Elowen was yelling, but the defendant said it was a combination of things. It was not just because Ms. Nafsir was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond reasonable doubt on knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or the state of the evidence at this point does not justify dismissing them on a self-defense ground because there is sufficient evidence for the jury or the rational trier of fact to find in the state's favor on the self-defense issue. Moving to reckless conduct under 631(3), the elements of that are the defendant engaged in conduct that either placed or may have placed another person in danger of a serious bodily injury, and that he did so recklessly with a deadly weapon as a firearm. In this case, the defendant, by his own admission, grabbed Elowen and then fired a gun at Elowen's mother while holding her so close that she complained instantly that her ears hurt. Reckless conduct does not require actual injury. It does not require evidence of actual trauma or actual diagnosis of injury. In this case, we do in fact have the testimony of a doctor who said she sustained an injury to her ear. That was what the doctor said. The defendant used a deadly weapon, and that deadly weapon was a firearm. The defense argument focused on the fact that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms, and that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what they're saying the evidence shows, then Elowen is somewhere within the room, not in his arm, not confined. I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elowen, however, it is a risk of any injury, including injuries to the ear or to Elowen's hearing. There is testimony about that in the light most favorable to the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find beyond reasonable doubt for the state. With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we are talking about injury to the welfare of a child, not physical injury. The cases on this crime that describe other versions of this, where people have been convicted and those convictions have been held, speak of situations involving, a caretaker getting high or drunk with a child in the car, certainly while driving, but in other instances, just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Elowen's mother in front of her. Although he told the police that he didn't think she saw anything and he hoped she didn't. She told the doctor that mommy and daddy were fighting. Daddy hurt mommy and me, and there was a lot of blood. In the light most favorable to the state, certainly it is clear that Elowen knows what happened. Elowen is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence sufficient at this stage that by shooting Caitlin in the head, the defendant endangered Elowen's welfare. We are not claiming that he injured Elowen beyond by shooting her with a gun. But when we're talking about endangering the welfare of a child, psychological injury or psychological welfare comes into play, emotional welfare, and that is what we're talking about here. It does not have to be evidence that Elowen is actually in therapy or that she has actually been diagnosed with a mental health issue for it to be shown that the defendant endangered her welfare by doing things that he did. The dual standard here that the defense mentioned is the standard. Purposely violating a duty and knowingly endangered the welfare. There's a case on that addresses it pretty well. Defense cited INRI NK. That case, I think, discusses that standard in a good way. Also, State versus Bortner. I don't have the site, I just have the name, but BORTNER specifically discusses the interplay between knowing and purposeful. That is not a legal issue. And Bortner talks about a failure to act rather than an affirmative act. But
Cite on Bortner?
excuse me?
You cite?
I don't have one. I
Okay.
apologize.
No.
I don't have it on me.
Thank you. Okay, no, thank you.
right down the end of it. Knowingly endanger and purposefully violate. I don't think that it is in dispute that by shooting Ellen's mother in the head in front of her, that the defendant purposely violated the duty of care. He had to know, anyone in that situation would know, that that would seriously compromise and seriously risk danger to a child's welfare, psychologically and emotionally or otherwise. And purposeful violation of that duty of care that he owed to her. I think the knowingly engage in conduct speaks to the act. And we have already argued that the defendant acted knowingly. I think that's all the state has at this point. We ask that the motion be denied.
Okay.
Your Honor, 150 New Hampshire 504.
504, thank you. Okay, thank you. Attorney.
Just one comment, Your Honor. I think I said it in my motion that the state didn't offer any evidence of psychological injury or trauma or anything. It's speculation based on what it feels like. There was no evidence. And I'll leave it at that.
Okay, thank you. In response to that?
No, I don't think it's reasonable inference that shooting a child's mother in the head would endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and the arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State versus Wong, 138, New Hampshire 56, 1993, State versus Burke, 122, New Hampshire 565, 1982, and State versus Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss. With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony, referring to Mr. Duren, as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627.4, Roman numeral 2, at this point in the proceeding, I would find, once again, at this point in the proceeding, I would find that there has not been evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, that no reasonable trier of fact could have found that the defendant did not act in self-defense if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that takes care of the instant motion that is before the court. Attorney Kinney,
Yes, Your Honor, I think so.
anything further?
No.
Okay. Attorney Spicer, anything further at this time? No? Okay.
I think he's indicating no as to that motion, Your Honor, but we do have an additional
Okay.
motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No.
Okay. Attorney Durand?
Mayor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumunden and/or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present along with Ms. Plumunden in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlin Nafziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumunden would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlin Nafziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently, based on some level of fairness argument or and cited to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumunden and Ms. Nafziger, and that supposedly that Ms. Plumunden will be testifying to that plan, but the court believed based on its reading of the transcript and based on some level of a value of fairness that Mr. Duran was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan and that he would need to have knowledge of such a plan, or at least of the desired result, in order for this information to be admissible. He would have to know that Ms. Plumunden was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant's saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said. And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material. But by its own ruling, the court has said Ms. Plumunden can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe, and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumunden and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Nafziger, and for the support for these arguments that she was going to kidnap the children, and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Nafziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Nafziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, and with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumunden with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Okay, thank you, Attorney Duran. Attorney Kittle?
Yes, Judge. I would reiterate all the arguments made in our objection, written objection in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we discussed at length previously, that Mr. Duran was aware of the plan. I'll note a couple of things. I think that the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that like a statement that was made to Ms. Plumunden about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumunden's testimony about a current plan, it does apply under 8033. I'll just note a couple additional things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Nafziger had this plan. Ms. Plumunden has told that to detectives, to our investigator. She sent a text saying you need to help plan a kidnapping. And so if the state's going to argue that kidnapping is a fabrication of the defense, that's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but as there's been evidence of Ms. Nafziger's aggression. The state introduced that statement. The state pressed play on a video that had a statement about Ms. Nafziger's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duran, any response?
No, Your Honor.
Okay. Satisfied with the record relative to those issues?
Yes, Your Honor.
Okay, all right. I'm going to deny the state's motion to reconsider on that aspect. I've ruled several times on this matter. I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that. Miss Brenda Plumondon is our witness, but Miss Spurgeon, Trooper Pratt, Arthur Booton are all here in case we need to call them for rebuttal purposes.
All right.
I do have a request before Miss Plumondon comes in, Your Honor, but it's about her testimony.
And I'm just going over my notes relative to the state's. Okay, again, I'm going to restate part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duran through Sergeant McLaughlin, it is clear that at several points in that statement, Mr. Duran referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time, after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Nafziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? There was a number of times in which Mr. Duran was asking what was happening to Ms. Nafziger, according to his version of events. And based upon the defense argument relative to the introduction of Ms. Plumondon, am I pronouncing it correctly? Plumondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Nafziger, and not with respect to the reasons for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court. And I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Durand, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plumondon is here. Well, I believe she is. I haven't seen her today, but okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that something might be said to cause a mistrial. So I'm asking for two things. Number one, for the court to have a colloquy with her outside the presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a natural desire to try to explain things. And I would like to be able to lead a very typed and specific questions to produce the testimony that you have deemed to be admissible. I will note that the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think that the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plumunden for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plumunden is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plumunden because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her. And now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered. But that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern. And I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form. Defense wanted to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions. There's no indication that Ms. Plumunden is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her, but the consideration.
If I may interrupt really quickly, the Zwicker letter says Ms. Plumunden was asked 2 questions and provided the answers to those 2 specific questions. And that is it.
Okay, so you talked to her though.
2 questions. What was Valen's date of birth? I do not know. Was Caitlin Nafziger breastfeeding? No. Those were the questions.
611-2, C2.
That's what I'm looking at.
Okay, when a party calls a hostile witness an adverse party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Plumunden about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I have not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So for that, there's 2 reasons that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
Okay. Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duran, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay. All right. Thank you. Okay. I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been subpoenaed, number one, that she has been subpoenaed here and that she's going to be asked questions and that she's instructed to, is she prepared to ask, to answer the question that she is asked? Are you prepared to answer the question that you are asked? And are you prepared to limit your testimony to the question that was asked and not to volunteer further information? That's sufficient, Attorney Kinney?
And Your Honor, I think it would also make sense to instruct her specifically in accordance with your order that we're talking about the what of the plan and not the why of the plan.
And finally, that she's not to testify about statements allegedly made by Caitlin. That she can testify as to her perception, her understanding of what her understanding of.
Just a question for clarification, and it's why the state has asked so many times for the motion to be reconsidered. Is Ms. Plumundon then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Knapsinger? Or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Knapsinger?
And I've already ruled that relates to her understanding as to that, not relative to indirect hearsay. She can't testify as to what Caitlin said to her, but she can testify as to what she understood the plan to be. Anything further, Attorney Kinney?
No, Your Honor.
Okay. Attorney Duran, anything further right now?
No, Your Honor.
Okay. 10-minute break.
Thank you.
Okay. Good morning. Thank you. Please be seated. Okay, we're back on the record outside the presence of the jury. Good morning, Ms. Plumondon. Am I pronouncing that correctly?
Yes,
First thing, Ms. Plumondon, if I could have you raise your right hand, please. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
yes.
Okay, thank you. Can I ask you to please spell your last name for the record, please?
Plamondon.
Thank you. Again, thank you for being here. I understand it's under subpoena. Have you spoken with Attorney Kinney about the scope of your testimony?
No,
Ms. Plumondon, I am allowing the defense attorney to call you as a witness in this matter, but I've placed significant limits on the scope of your testimony. Okay. And has anybody told you that?
the defense attorneys just let me know that a minute ago.
Okay. All right. I'm going to go over that with you now in an effort to just make sure that we're on the same page before the jury comes back in.
Okay,
Okay, thank you. When Attorney Kinney, the lawyer for the defendant, when Attorney Kinney asks you a question, are you prepared to answer the question that was asked by Attorney Kinney?
yes,
And when you answer her questions, are you prepared when testifying to not volunteer further information other than what you were asked about?
yes,
Okay, thank you. Now, I want to also let you know that the state will have the opportunity, when Attorney Kinney is done, The attorneys for the state will have the opportunity to ask you questions as well. So that may clarify some of what you are asked by Attorney Kinney, but they will be operating under the same orders and rules that I have put in place relative to what they can and can't ask you. So it's not just Attorney Kinney asking you questions. The state will have the right to ask you questions as well. Okay?
Okay.
Okay. And Ms. Plamondon, the questions are going to be based upon what you knew at certain points in time. Okay? They're not going to be based on why you knew them. In other words, it's not based upon what Caitlin told you or why certain things were being done. It is limited to what you knew at the time.
Okay.
Okay, in other words, your knowledge as to what was happening at certain points in time. That is what your anticipated testimony will be, at least with respect to the questions being asked by Attorney Kinney.
Okay.
Okay. Specifically, it will be about what you understood, your personal understanding as to any plan that you might have had with Caitlin.
Okay.
Okay. It doesn't include Caitlin's specific statements to you as much as it is what you understood the plan to be.
Okay.
Okay. In other words, it's limited to your understanding at certain points in time. And I understand it's difficult on many levels. I'm simply going over what the court's expectations are at this time. Do you have any questions of me, ma'am?
No, I understand.
Okay. At this point, Attorney Kinney, any further comments or inquiry by the court that you would request?
No, none, Your Honor.
Okay. Any from the state at this time, Attorney Duran?
Nothing.
Okay. So I'm going to bring the jury in, and once again, if you have any questions of me, I realize this is a difficult process. If you have any questions of me, we can try to go over them now. I'll give you just a moment.
If there's a word or something that doesn't fit, is it just a no answer then? If,
Just answer honestly, answer the question that Attorney Kinney or the attorneys from the state ask you. Just answer honestly to the best of your ability and to the best of your understanding as to what you understood at the time relative to any plan with Caitlin.
okay.
Okay? I appreciate your ability to follow the court's instructions. Okay, thank you.
Yes.
Anything further? Okay. Again, manager is present. Sure. Thank you.
All rise for the honorable jury. Cook County Superior Court is now in session. The Honorable Jonathan S. Frizzell presiding.
Okay, thank you. Please be seated. Now, Ms. Plamondon, if I could have you raise your right hand. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
Okay, if I could have you state your name, please, and spell your last name for the record.
Brenda Plamondon, Plamondon.
Thank you.
Good morning, Ms. London. I just have a few questions for you. You live in New Hampshire
Yes,
and you have 2 children?
3.
3 children. And Caitlin Nafziger was your niece by marriage?
Yes,
And Ellen and Valen are her daughters?
yes,
At any, they never lived with you though, correct?
no,
In early of 2024, Caitlin reached out to you about coming to visit,
yes,
and she didn't give you much detail about her visit at that point, right?
yes.
Um, So yes, she did not give you detail?
She did not give me much detail.
Okay, thank you. And in later February, she reached out again with information that she was going to come to New Hampshire.
Yes,
And you knew that she had a plane ticket to Boston, correct?
yes,
And that she was bringing the baby Valen with her, correct?
yes,
But you didn't know where she was going to stay, right? Before she got to Boston?
yes, that's true.
Okay. Or if she needed to borrow a car, right?
Right, I had offered.
You had offered, but you weren't sure. She never responded yes or no, right?
True,
Okay. But Caitlin and Valen did come to Boston in late February 2024, correct?
yes,
And they stayed with you the first night they arrived
yes,
in Hampton?
yes,
Okay. And you and Caitlin and Valen stayed the night in Hampton. Was anyone else there?
yes,
Is that Shannon
yes. And my husband, Mark.
and your husband, Mark? Shannon is your friend?
Yes,
So that night at your home was the first time you really got to talk to Caitlin about her visit to New Hampshire, correct?
yes,
Okay. And that Caitlin was there, her plan was to go up and get Ellen and go back with both kids to Minnesota, correct?
yes,
Okay. And so you and Shannon and Caitlin talked about how that plan would play out, correct?
yes,
Okay. And you knew that Caitlin had a return ticket to Minnesota, correct?
yes,
And you would offer to pay for Ellen's ticket back?
yes,
Okay. So the plan was that Caitlin and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
no. Sorry.
Approach Adam. Correct?
Yes,
Okay, and that was a recorded phone call that you
Ye-
gave them?
yes,
You agreed to be recorded,
yes,
and you told them everything that you knew at the time, correct?
yes,
And you didn't leave anything out?
to the best of my knowledge.
And you had a chance to look at the transcript of that recording, correct?
Yes,
Okay. And I'm going to show you page 7 of your transcript. Where you say line
assume it's-
9,
I assume it's being used to refresh your recollection.
I'm impeaching her, Your Honor.
Your objection.
Approach.
Did you, you were able to review the transcript of your interview? that you
Ye-
did?
yes,
Okay, and was it a fair, and does it look like this? Does the copy that you were given look like this?
What is this defense exhibit, what?
ID, D.
Thank you.
I don't know, it was an email.
Okay, well, why don't you take a look at that and let me know if that looks like item you reviewed?
Yes,
And is that a fair and accurate uh, transcript of what you told the troopers in March of 2015, March 15, 2024?
some of it was mislabeled of what Shannon said and what I said.
And so I also have clips. Were you able to listen to the video?
No,
Okay. So, Your Honor, can we approach?
Yes.
Okay, Ms. Clement, please review page 7, line 7 to 18, and then I'll ask you questions again of ID, defendant's ID, Exhibit D.
okay.
So again, the plan was to go to Berlin and wait for Caitlin and the girls to come meet you at a restaurant or somewhere and take them back to the airport.
No,
Okay, so can you tell us what the plan was?
that we were waiting for Caitlin to call us and tell us how she needed a ride and that we would meet her wherever we needed to meet her. And if by Saturday we hadn't heard from her, that we were just going to go to Berlin and wait to hear from her so that we would be closer and ready.
And the plan was to get them back to Minnesota, all three, Caitlin, Valen, and Elowen, as quickly as possible.
Yes,
The next day, after that plan was discussed, you offered to drive Caitlin and Valen up to meet Dustin, correct?
kind of.
Okay, Did you drive her up to Ossipee?
Yes,
Okay. And you drove with Shannon, Caitlin, and Valen, correct?
yes,
Okay. And you drove Caitlin and Valen to the designated meeting place, which was a restaurant in Ossipee, correct?
yes,
Okay. And Caitlin brought a suitcase with her, correct?
yes,
She had a bag of like wet laundry because there was an issue with the dryer.
yes,
Okay. But she did leave behind other things, right? Like her backpack,
yes,
kids' birth certificates.
yes.
Would you like a break?
Okay,
Okay. I only have a few more questions. You didn't see Dustin or Ellen when you dropped Caitlin Valen off, right?
no,
And after you dropped them off, you called Caitlin's mom to tell her what the plan was, right?
no,
Okay, you called folks though to talk to them?
yes,
Okay. Those folks being her mom
yes,
and her dad, Rob?
yes.
I don't have any more questions. Thank you. Horse indulgence. You're welcome, sir. Okay,
Yep,
There's some water there. Do you have some?
yep.
Okay. Do you need to take a minute?
Nope, I'm okay.
Okay. Ms. Plumunden, you live in Hampton, New Hampshire, correct?
Yes.
How long of a drive did you have to come to court?
I don't know, like 2.5 hours, I think?
Are you familiar with this part of the state?
No, I'm not.
Had you ever been to Berlin, New Hampshire before?
No,
Have you still to this day been to Berlin, New Hampshire?
I have not.
Now, Caitlin Nafziger, she flew from Minnesota to Boston on February 27th of 2024, right?
Yes,
And then she took a bus to New Hampshire?
yes,
And then you and or Shannon picked her up from the bus stop.
yes,
She and Valen, her youngest child, they spent one night with you in Hampton, correct?
yes.
Can you tell us during that time, did you have a chance to observe Caitlin and Valen together?
Yes.
What were your, without telling us what anyone said, what were your observations of their relationship?
What a good mom she was, and how relaxed the relationship was, and just how happy she was. Both of them.
Had Caitlin ever come to see you in New Hampshire before?
Yes.
How many times?
At least 3, maybe more.
How long had it been since the last time she'd been here?
We have a holiday called Thanksmas, and she,
Thanksmas?
yes, and we
Okay.
do everything that we've always done, Christmas to Thanksgiving in 1 week, and all the family gets together. And so she was there for that, as was her mom and husband and other family members.
Her mom's husband?
Mhm. Yeah, her mom Lori and
Okay. Just making sure I know
yep,
who you're
yep,
talking
and
about.
Lori's husband Tim and my kids, and
Had Caitlin ever been to Berlin, New Hampshire?
no,
Not before February of 2024?
No,
Did she have any friends in New Hampshire?
no,
Were you her only relative in New Hampshire?
yes,
Besides your husband as well, right?
yes, yes,
And your kids?
yep,
And you, and I don't mean this to sound improper, but you're related to Caitlin by marriage, correct?
yes.
Now, on February 28th, so the very next day, I mean, Caitlin was in your house for, when did she get there on the 27th? In the morning? Or was it nighttime?
It was evening and I was working and coming from Boston, so I didn't see her until like 5 p.m.
Okay. So at some point, sounds like less than about, I don't know, less than a day later,
Mhm.
you drove Caitlin to that restaurant in Ossipee, New Hampshire, correct?
Yes,
A place called Harley Jack's?
yes,
Does it take, fair to say it took you over an hour to get there?
yes,
Had you ever heard of it before?
no,
Ever been there?
no,
When you got to Ossipee at Harley Jack's restaurant, Caitlin got out of the car?
yes,
She took Valen out of the car?
yes.
Was Valen in a car seat?
Um, yes, it was like a car seat that fits into the stroller.
One of
Okay.
those like dual, like
Right.
pop it in and out things.
Right, but
Okay.
she left the stroller portion at my house.
Okay. You didn't go inside the restaurant, right?
No,
When Caitlin got out of your car and took Valen, without telling us what she said or did what she said, how was she behaving?
um, I mean, it was quite a sad sight, and Shannon and I both cried. You know, she's such a small person, and she had this big, enormous suitcase, and you know, she had the baby in the car seat, and she was just like lugging it. I felt awful for leaving her there.
But you did leave.
Yes, she specifically asked that we not come in because
So you left.
yes,
Okay. You didn't see the defendant at Harley Jack's?
no,
And just so we're clear, do you know the defendant?
yes.
How do you know him?
We have FaceTimed many times, and I, you know him as the father of Phelan and Elowen, and because of Caitlin's relationship with him.
You didn't talk to the defendant when when Caitlin was in New Hampshire, correct?
No,
You didn't talk to him in Ossipee in the parking lot?
no,
You didn't talk to him over the phone after you left Caitlin in the parking lot?
I don't even have his contact information.
He didn't speak to you?
No,
Did you leave before Caitlin went in, or did you watch her go in?
we left as we parked far away in the parking lot and left as she was walking through the parking lot.
So you didn't wait in the parking lot until they finished lunch and left the restaurant, did you?
No, I had no
Yes.
contact after she got out of the car.
And when you left the parking lot at Harley Jack's, where'd you go?
Home,
Okay, so you drove the hour back to Hampton?
yes.
You didn't follow them back to Berlin?
No, I was working and it was 5 o'clock, so Shannon had driven up there, but now I was done working and I shut my laptop and I'm like, oh, I can drive home. And she's like, great, because I don't see well at night. So,
So you wanted to get home?
yeah,
You'd agree that your home is at least 2.5 hours away from Berlin?
yes,
Now, what defense has asked you about in terms of this plan is that you were going to, the plan was for you to go up and sit at a restaurant on Saturday, correct?
if we hadn't heard from her at that point.
Okay. Did there ever come a time that you heard from Caitlin?
No,
When you dropped her off in the restaurant parking lot, was that the last time you saw her?
yes,
As part of the plan, did you choose a safe word?
yes,
What was the safe word?
that
Your Honor, can we approach? Did she have a bus? A code word, correct?
I don't recall.
And if you got this code word, you were gonna drive 2.5 hours? Is that fair to say?
And call 911.
Was part of this plan to tell the defendant about it? Would that have made sense to you?
To, about the
tell him?
code word?
No, to tell him about the plan in general.
No,
Was Caitlin gonna tell him about it?
no,
Was your plan designed to hurt Elowen?
no,
Was your plan designed to harm either child?
no,
Was any part of the plan to seek money?
no,
Was there any part of the plan that had Caitlin telling the defendant that she was gonna call the police to take custody of the children?
no,
Was there any part of this plan that required Caitlin to tell the defendant that she was gonna take the children back to Minnesota?
no,
Did Caitlin have a car with her?
nope,
Did she have a rental car reservation anywhere?
no,
Did she have a bus ticket?
no,
Was Caitlin familiar in any way with the area in Berlin, New Hampshire?
no,
And the plan was that she would have the 2 children with her, correct?
yes,
Caitlin never texted you to say that she got into the restaurant okay?
no,
She never texted you to say the defendant was there?
no. She specifically said she couldn't text because he would control her phone.
She didn't call you to say that they were leaving the restaurant?
No,
Did she send you any?
Answer relative to controlling the phone, and I instruct you to give it no weight whatsoever.
She didn't call you to say that they left the restaurant, correct?
no, she did not.
Did she send you any photographs of her with the 2 children at his apartment?
No,
Did she text you at any time and say, help, please come?
no,
Did she ever text you a code word?
no,
Did there ever come a time that you heard from Caitlin after you dropped her in that parking lot in Ossipee?
nope,
Was that part of the plan?
no.
I have no other questions.
And part of the plan was for Caitlin to take both children while Dustin was asleep, correct?
No,
That, you didn't discuss how he plays video games and stays up all night?
Objection, Your Honor, outside the scope.
Approach, Your Honor. Ms. Clemente, is it fair to say that the plan was for Caitlin to get the girls from the apartment and leave without Dustin knowing?
yes,
Thank you. No more questions.
Court's indulgent. Ms. Clemente? You've just testified that the plan was for Caitlin to leave with the two girls, correct?
yes,
Without the defendant knowing.
yes,
Caitlin did not have a car,
right,
did not have a bus ticket,
right,
did not know the area.
right,
You were 2.5 hours away.
yes,
She didn't know anyone else in the state.
no,
It was February in Berlin, New Hampshire.
yes,
Fair to say the temperatures range between -2 and 32.
yes,
Fair to say that it was snowing that week.
This is beyond the scope.
Overruled.
I don't recall.
I have no further questions.
Okay, council approach, please. Talk to them, but other than that, thank you for following my instructions, and we'll reconvene again at 12:45. Thank you. All right. Of counsel, but I think under all of the circumstances, with respect to highly competent and experienced counsel from defense, I have no issue whatsoever with respect to the scope of their representation and their likely discussion that they would have had with their client. So I will decline to do that at this time unless there's any specific reason from the defense standpoint.
No, Your Honor.
Okay. All right. All right. Thank you. I did request that the jury be back at 12:45. I don't know how many are back yet.
Still waiting on a few.
Still waiting on a few? Okay. So we will take a brief recess then, unless there's anything further. We'll take a brief recess until all the jurors are here, and then we'll start promptly once we have all of them here. Okay? All right. Thank you.
All right.
Your Honor, the defense calls Dustin Durham. Mr. Durham, please remain standing. Please raise your right hand. Do you swear that the testimony you give today will be the truth under the pains and penalties of perjury?
Yes, I do.
Okay, you can go ahead and sit down. Please state your full name and spell it for the record.
Dustin, Dustin, Duren, Duren.
Dustin, I wanted to start by asking you, are you a father?
Yes, to the loves of my life, 2 daughters,
What are your 2 daughters' names?
Elowen and Valen.
How old are they?
They are currently 5 and 2.
Are you a veteran?
Yes, I am.
What branch did you serve in?
The Marine Corps.
When did you enlist?
So I enlisted right out of high school. So a week after I graduated high school at 18, I left for boot camp.
Where did you go to boot camp?
So this was in Camp Pendleton, California.
Did you do infantry training?
Yes.
Where did you go to infantry training?
So that was at the same place, Camp Pendleton, California.
In the Marines, did you receive training with firearms?
Extensive training, yes, to where you're expected to assemble, disassemble, load, fire with the highest of proficiency, and they drill it over and over and over to where they want it ingrained in you, to where it's instilled in you. It becomes instinctual.
What's instilled in you?
The use of your weapon, whether it's rifle, pistol.
Were you taught about firearm safety?
Yes. The Marine Corps specifically has 4 rules.
And what are they?
And this is something that I teach even just outside the Marine Corps, but these are rules that I think really everyone should follow. This isn't just a Marine Corps thing, but number one, treat every weapon as if it were loaded. Two, never point your weapon at anything you do not intend to shoot. Three, keep your fingers straight and off the trigger until you're ready to fire. And four, keep your weapon on safe until you intend to fire.
And you've talked a little bit about it, but can you tell me, as a Marine, what familiarity with firearms were you expected to have?
Absolute familiarity. I mean, you spend a lot of time with it. You're expected to be combat ready, and that's something else with the Marine Corps, specifically to the Marine Corps of every Marine is a rifleman.
What does every Marine is a rifleman mean?
So, like I said, this is something specific to the Marine Corps. So it doesn't matter what your job is. So you could be a cook, but before you even go through your job training, you're expected to go through infantry training.
And what is the point of going through infantry training, regardless of specialty?
So that everyone is combat ready, is trained with a rifle, trained to be a warfighter first.
And is that different than other branches of the armed service?
Yes, yeah.
In boot camp, did you receive any recognition for your proficiency with firearms?
So right away in boot camp, I graduated as the battalion high shooter.
What does that mean?
So in our marksmanship course, I was the highest shooter out of our entire graduating class.
Does that mean you were the most proficient with a rifle of everyone
Yes,
you went
yes.
to boot camp with? Did you do any other type of combat training in boot camp or in infantry training?
So specifically in infantry training, you train with all sorts of different weapons. So we were training with like the M240 Golf, heavy machine gun, Mark 19, automatic grenade launcher. But and then two, we in hand-to-hand combat, we have or close quarters combat, we have a program called McMap.
What is McMap?
And that is the Marine Corps martial arts program. And it's different from most other martial arts in that specifically other martial arts, you're learned to incapacitate, or get away. And with McMap, you're specifically trained to kill, really by any means. But this is in the use with just your hands, or with pistols, with close quarters, with a rifle, just everything close quarters related.
And let me just make sure I understood that right. The Marine Corps martial arts program, you're learning martial arts combining unarmed combat and weapons-based training?
Yes.
Let's jump from training to deployment. Where were you first deployed?
So I was first deployed to Japan, Okinawa, Japan.
Did you do any firearms training or qualifications in Japan?
Yes. So every year, again, regardless of what your job is, you're expected to go through an annual marksmanship training and qualification. So right away, once I got to Japan, then I did the annual qualification. But then again, I was squadron high shooter, and they tagged me and asked me if I wanted to become a coach.
Why were you asked to become a coach?
Again, really, it's I was just kind of tagged, like people noticed with me being the squadron high shooter.
So because of your proficiency with
Yeah,
firearms?
yes.
What did you have to do to become a coach?
So there's the combat marksmanship coach course. You go really beyond what you would normally go through, or the training or the qualification. You do much more, whether it's like just regular target practice, or you could be doing moving targets, yourself moving, but just a lot more in detail. And then you're also taught specifically how to teach others.
How did you do in the coach's course?
So again, in the coaches course, I was again the highest shooter, and beating out. There's mainly a lot of other infantry Marines, but there's also specifically there's two Force Recon Marines there, which Force Recon that's it's basically like Navy SEALs or Army Rangers of the Marine Corps.
So you outshot the Marine version of the Navy SEALs in the coach's training course?
Yes.
After you took the coach's course, did you serve as a marksmanship coach?
Yes, I did.
How did you serve as a coach?
So again, then at that point, I was a combat marksmanship coach. It was just called like a B billet, but it was secondary to my normal job. But I would then train other Marines in this annual qualification or whenever Marines need to qualify, and ended up teaching hundreds of Marines.
And what did you teach hundreds of Marines to do?
To perfect their shooting, their proficiency with rifle or pistol.
During your time in the military, can you estimate how often you discharged a weapon or how many times?
Thousands, probably tens of thousands.
And what did discharging a firearm tens of thousands of times do?
And it gets instilled in you to where, like, I guess you could say you could do it in your sleep. It's just so ingrained in you that they really want you to do it with basically without conscious thought. Like it just, it's so drilled in you over and over.
What were you trained to use a firearm for?
To eliminate threats.
Besides Japan, where else were you deployed?
So I was deployed all over the Pacific. So Philippines, Thailand, Korea, and then also to Kuwait and Iraq.
When were you deployed to Iraq?
So this would have been 2008.
Where in Iraq were you stationed?
There's a Marine base called Al-Assad.
Did you experience any violence or danger in Iraq?
So at the time, 2008, so the big things then were IEDs or improvised explosive devices and mortar attacks. And then I did take small arms fire from my helicopter, small arms being like rifles, AK-47. And then specifically for my job as an aircraft recovery specialist, we dealt with plane crashes or like emergency landings, which happened when I was there.
You said you took small arms fire from a helicopter. Does that mean you were shot at while you were in a helicopter?
Yes, yes.
Did anything else traumatic happen while you were in Iraq?
Yes. So I was back at sort of our home area. So when you're in Iraq, you're basically just working 24/7. But
The question in front of you, just I think ask it as narrowly, answer as narrowly
Okay.
as you can, is when did you first start experiencing symptoms from your PTSD?
okay, with that direct question, immediately afterwards.
Immediately after you were discharged from the Marine Corps?
Well, no, immediately after the event itself.
Immediately after the event itself?
Yes.
And what year was that?
2008.
That was while you were in Iraq?
Yes.
When did you get a diagnosis of PTSD?
Officially, this would have been 2021 or 22.
So after almost 15 years of experiencing symptoms?
Yes, yes.
When were you discharged from the Marines?
So this would have been 2011. I was honorably discharged in 2011
You were honorably discharged at what rank?
as a sergeant.
After leaving the Marines, where did you move?
I moved to Los Angeles, California, to where that's where I got my degree in audio engineering, and then I was almost immediately hired at Fox Sports as a post-production audio engineer.
Were you experiencing symptoms of PTSD or depression while you lived in Los Angeles?
Yes.
Where did you live after LA?
So afterwards, which this was just part of my sort of severe depression, but I ended up moving to Las Vegas, Nevada, and that made sense just for my work and also working as an event technician. So working at for like corporate events and music events in Vegas.
How was your mental health when you first moved to Vegas?
It was
Objection. Relevance.
Approach.
Overruled.
Dustin, how was your mental health when you first moved to Vegas?
It was extremely bad. So that was part of why my move happened, but it only got worse as I was there. And along with another traumatic event, that's when I had a suicide attempt.
Were you hospitalized after your suicide attempt?
Yes,
Where did you go after was it a psychiatric hospitalization?
yes.
Where did you go after your psychiatric hospitalization?
So this was a little bit afterwards. My parents were trying to convince me to live with them, to come back to Minnesota and basically just try to take care of myself, take care of my health, and just be with family for a while. So it took a few months afterwards, but eventually I agreed and moved back to Minnesota, and this would have been November, December of 2018.
You moved back to Minnesota in November or December 2018?
Yes.
When did you meet Caitlin?
So this was shortly afterwards, maybe about this, well, yeah, it would have been like 3 months later, February of 2019.
Where did you meet?
So it was at a bar, and I remember it specifically because the Super Bowl was on.
Did you two start dating?
Yes, probably about a week or two later.
When did Caitlin get pregnant?
Almost immediately. So I think I found out it's probably April of 2019.
How did you feel when you found out that Caitlin was pregnant?
There was a mix of emotions. So this was not planned. This was unexpected. So I was kind of anxious about it, but at the same time, I got pretty excited about just having a family, starting a family.
Had you always planned on having a family?
I did. Came a little early, but yes.
And was Caitlin pregnant with your daughter, Elwyn?
Yes.
Did you and Caitlin move in together once you found out she was pregnant?
Yeah, so I don't remember the exact time, but it probably was around that time, April 2019, in which she moved in with me at my parents' house.
How were you involved during the pregnancy?
I tried to be involved as much as possible. I was going to all the doctor's appointments, just trying to take care of Caitlin as much as I could. Just like her being happy makes the baby happy. So just, trying to take care of her as much as I could as well.
How was your mental health immediately before Caitlin got pregnant?
Before it was still pretty bad. I was seeing a psychologist. Not great.
Can you tell me what you mean by not great?
I was still dealing with some pretty bad depression, and just my life just kind of feeling meaningless, or just really without purpose.
How was your mental health during Caitlin's pregnancy?
So it improved pretty quickly, with just being so excited about starting a family.
Did it make you feel like you had a purpose?
It was starting to, yes.
Tell us about the day that Elwyn was born.
So it was December 2nd. So right away in the morning, Caitlin woke me up and told me her water broke, and we went to the hospital. the labor was long. It was about 13 hours. Um, but yeah, once Ellen was born, she was placed on Caitlin's chest, and but immediately she was turning purple and wasn't breathing. So immediately I'm yelling at the nurses like, "Hey, something's seriously wrong here." Um, they grab her, they take her to the side. They end up restarting, like she's started to breathe again. But then they ended up taking her to the NICU, to where she ended up spending a week there. Everything was fine, but they were just doing that as a precaution.
Where were you and Caitlin while Ellen was in the NICU?
So for the most part, we were with her. Uh, so we didn't really want to. Obviously, we wanted to be with her all the time, and then we would sometimes try to get back to the house just to like shower or whatever, try to get some sleep. And but yeah, for the most part, in the NICU with her.
Tell us what it felt like the first time that you held Elowen.
It was beautiful. This was, hey, I have my first child. It was amazing.
When Elowen was discharged from the hospital, where did the three of you go?
We moved back with my parents at their house.
And this was in Minnesota?
Yes.
How did it feel to take Elowen home from the hospital? How did it feel to take Elowen home from the hospital?
Again, amazing. Again, it was. I just felt so happy just having this family, just being together as this family.
Did you spend a lot of time with Elowen when she was an infant?
All the time, as much as I could. Always being by her side. I mean, whatever, just, I don't know, bassinets, is that what they're called? Whatever, wherever she was sleeping, wherever she was, I always wanted to be near her, just always being with her. She actually had this little, it was like a little unicorn handkerchief or blanket, I guess. But she always had it since she was born, and she would make these noises like goy goy when she had it, and that we ended up calling it goy goy, and she still has it today, and that's still what we call it, her goy goy.
What did you like to do with Elowen when she was an infant?
Well, I definitely like to show her off a lot. Just going to see different family, friends. Yeah.
When she was an infant, were you worried about Elowen's safety?
Of course. I was always watching her, always protecting her, to where just even if she's on the bed, like is something over her, like is she gonna roll over? Would she roll off the bed? Or like if she's laying on the couch for some reason, is she gonna roll off the couch? I was just always watching her.
How long after Elowen was born did you stay in Minnesota?
So this was about 6 months. So it would have been June. Yeah, I think like June of 2020. And at this point, so I had talked about how I was only ever in Minnesota temporarily, and my plan was always to go back to Nevada eventually. And then, so obviously I got disrupted a little bit with Elowen being born, but and then actually 2020 as well, that was during COVID. And so my work wasn't really available. Events were not really happening in Vegas. And so I was trying to find work. And it just worked out that I happened to find a job at the United States Postal Service as a mail carrier. So
And so let me just make sure this is clear. So you said you left Minnesota in June of 2020. Is that when
yes,
you moved to Vegas?
yes, that's when I moved to Vegas.
And you moved there because of a job with USPS?
Yes,
Uh, Did Caitlin and Elwin also move to Vegas?
yes.
Were you looking for USPS for a long time?
Working for them, no. So once we moved there, I this had a lot to do with how much a mail carrier, specifically in Vegas, was working at the time during the pandemic. So where there was a lot of work, learning or working long hours, like easily over like 12 hours, probably 6 days a week. And my depression started coming back. I think a lot of it had to do with just me not being around Elwin and Caitlin. So I ended up quitting that around November 2020.
I'm going to ask you a little bit about your first Christmas in Vegas. Was Caitlin there?
No,
Where had Caitlin gone?
she flew back to Minnesota.
Did she take Elwin with her?
No,
Who was in Vegas with you?
so it was just me and Elwin.
How was your and Elwin's first Christmas in Vegas?
So this was again to where my depression was coming back, and really that first morning, all I had was just this little Christmas tree is probably about a foot tall, and then just a couple presents. And I was really starting to feel just sort of worthless again, like almost like I didn't deserve her. I couldn't provide for her, didn't deserve her. And but
Do you mean Elwin? You were starting to feel like you didn't
Elwin,
deserve
yes. And but she was so happy, and her just how happy she was, that became really just the most pivotal moment in my life. With everything I'd done, everything just paled in comparison to that moment of just she became my everything, my life. And from that moment on, she was my purpose, my meaning in life.
Tell us about what Elwin was like as a toddler.
Always happy, always run around, always learning. I tried to be good with always teaching her stuff. I remember sending it was a video to my mom, but she had flashcards to where they just had letters on them, like A, B, C, D, and then a picture of an animal on it. And I remember showing her or recording this and just showing Elwin these pictures or these flashcards, and her just rattling them off, getting them one by one, every single one of them correct, and just how amazingly smart she was, just even at such a young age.
How did you feel about being a father?
Again, it was amazing that it felt like that was my entire life, was being a father.
Were there any times when Elwin was a toddler where you were concerned about her safety?
There was a specific situation to where Caitlin was babysitting another kid. He was a little bit older, so Elwin would have been 2 or 3 at the time, and this other
Objection, Your Honor.
Approach.
rephrase. Is it fair to say that you continue to be concerned on alert about Eloin's safety when she was a toddler?
Absolutely, yes.
Did you do anything together with Caitlin to help ensure that your family was safe?
So yes, I taught her to use the pistol that I had. She had already known a little bit, but we went out. I took her out to the range a few times. We fired it. I make sure that she knew how to use it as well.
You testified previously about being a combat marksman coach for the Marines. Is that how you taught Caitlin how to use a firearm?
Yes, and not as an intense way, but yes.
And was it your understanding that Caitlin was proficient with a pistol?
Yeah, yeah.
You said you taught her with